Supreme Court of India 2023 SCC Online SC 1364 Indrakunwar vs State of Chhattisgarh decided on October 19, 2023. Facts of the case: convict appellant had relations with a co-villager, as a result of which she conceived a child, later on allegedly killed this child and threw the corpse into a dabri. FIR was registered after due investigation. The charge sheet was filed under Section 302 of the IPC against convict appellant. Trial court awarded life imprisonment. High Court upheld the conviction. Findings of the court: right to privacy, one of the most crucial human rights in the contemporary day. In many different countries and civilizations, privacy is cherished. It is also protected by numerous international and regional human rights treaties, including the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and many more. Is inviolable. Unfortunately, the view taken and the language adopted by both the courts below lays to waste such a right inherent in the convict appellant. It is apparent that the guilt has been placed on her without any solid foundation thereto, since no relationship of any nature whatsoever could be established between her and the deceased child discovered in the dabri. The conclusion drawn is simply on the basis that the convict appellant was a woman living alone and had been pregnant. As admitted in the statement under 313 CRPC, statement under Section 313 CRPC, the object, evident from the section itself, is to enable the accused to themselves explain any circumstances appearing in the evidence against them. The intent is to establish a dialogue between the court and the accused. This process benefits the accused and aids the court in arriving at the final verdict. The process enshrined is not a matter of procedural formality, but is based on the cardinal principle of natural justice, i.e., audi alterum partem. The ultimate test when concerned with the compliance of the section is to inquire and ensure whether the accused got the opportunity to say his piece in such a statement. The accused may or may not admit involvement or any incriminating circumstance, or may even offer an alternative version of events or interpretation. The accused may not be put to prejudice by any omission or inadequate questioning. The right to remain silent or any answer to a question which may be false shall not be used to his detriment, being the sole reason. This statement cannot form the sole basis of conviction and is neither a substantive nor a substitute piece of evidence. It does not discharge but reduces the prosecution's burden of leading evidence to prove its case. They are to be used to examine the veracity of the prosecution's case. This statement is to be read as a whole. One part cannot be read in isolation. Such a statement, as not on oath, does not qualify as a piece of evidence under Section 3 of the Indian Evidence Act, 1872. However, the inculpatory aspect as may be borne from the statement may be used to lend credence to the case of the prosecution. The circumstances not put to the accused while rendering his statement under the section are to be excluded from consideration, as no opportunity has been afforded to him to explain them. The court is obligated to put, in the form of questions, all incriminating circumstances to the accused so as to give him an opportunity to articulate his defense. The defense so articulated must be carefully scrutinized and considered. Non-compliance with the section may cause prejudice to the accused and may impede the process of arriving at a fair decision. Negative inferences cannot be drawn for a question or incriminating circumstance not put to an accused while making a statement. Present case is based on circumstantial evidence. It is a matter of record that none of the witnesses has seen the convict appellant throwing the deceased child into the dabri. No conclusive proof of any nature of relationship had been put forth by the prosecution. No evidence has been led to cast doubt upon the version of the convict. The statement of the doctor is silent on the death of the deceased having occurred prior to or after birth, although in examination in chief, the doctor has deposed that the death of the deceased child was homicidal in nature. However, in the cross-examination, it is admitted that such fact does not form part of the record, thereby calling into question the conclusion itself, as it is a vital piece of information that has been omitted. The conviction recorded on mere presumption. The High Court has confirmed the view of the trial court awarding life imprisonment without supplying any cogent reasons. Therefore, conviction is quashed and set aside. Convict appellant is acquitted.